The lawyer for Roberto Osuna insists that there is no implicit acceptance of guilt in his client's decision to accept Major League Baseball's 75-game suspension. Adam Goodman, this is something that we pretty much talked about when you had us on last time. So what do you make of what's happened? Now, first of all, I was under the impression that Roberto Osuna was supposed to show up in court on Monday. Why was he not required to be there?
They're just going for administrative court appearances. It's in what we call a set date court. It's going to be tons of other people, tons of other cases there, and it's just to give the court an update and say this is what's happening and then set another date for court. These aren't trials. They're not guilty plea dates. When the case is ready to proceed, it might be possible that he'll have to be there. It's also possible he'll never actually appear in court.
So there was mention made on a radio station about how they are effectively asking for more time. Is that what is happening here?
That's all that's happening. This is very typical in a case like this. What's happening is Osuna's lawyer and the Crown attorney are having discussions. It's possible they're looking for some more documents. It's possible Osuna's doing some counseling or some volunteer work. Something could be missing. I don't know. I'm guessing that these are all very real possibilities as to what's happening with this case. So absolutely nothing out of the normal, nothing unusual going on. They're just taking their time. They're going to put the case over, and eventually we'll see some finality.
According to his lawyer, they are seeking a resolution through a peace bond in which the charge would be withdrawn. First of all, what is a peace bond? And if this does go through and the charges are withdrawn, where does that leave Osuna in the public eye? I mean, I know you can't tell for sure, but does this mean that he is in some way admitting, yeah, I did do something I shouldn't have done? Or can you, as a defendant, still claim that you're completely innocent even though you're going for a peace bond?
The statement by the lawyer was the most interesting development that we've seen over the past week and a half, 2 weeks. There are two types of peace bonds. I don't need to get into the legal nuances of it. There's a common law peace bond and there's a criminal code peace bond. What they both mean is that you're signing a document and you're making a promise to the court that you're going to abide by certain conditions. The automatic condition is what we call to keep the peace and be of good behavior, and the likely other condition in a domestic situation such as this one is to stay away from the complainant, often there being an exception that you can have contact with what we call written and orally revocable consent. The bigger question is, what does it mean that he's signing this peace bond? A peace bond involves an admission that you did something to cause somebody to fear for their own safety or the safety of their property. So you're not admitting to an actual criminal act. There could be very many non-criminal acts that involves making that admission that you cause somebody to have this reasonable fear. And these are common resolutions for these types of cases all the time. Because it's the least risk-averse option. It's the path of least resistance. When the Crown offers a peace bond in a domestic situation, most people do end up taking it. Some don't. Some have issues making any type of admission, but most end up taking it. So what we're going to see is he'll appear in court, there'll be some facts read out, and his lawyer will probably then say, Mr. Osuna makes no admissions as to the factual basis, but we accept that there's a valid basis for him to enter into a peace bond. He'll sign the document, and the Crown will stand up and withdraw all the criminal charges.
Why would they do that, though? I mean, if the Crown and the plaintiff think that he did it and he's guilty, why wouldn't they say, you know what, I'm not signing any peace bond. I'm fighting you because I want you to pay for what you did.
Exactly.
If they think that he did it. You know what I mean? Like, why would they just accept it?
Well, keep in mind, it's the Crown's job to present a case to a judge. The Crown shouldn't be expressing their own opinion of whether or not they think somebody did it or not. They present the case and they argue for the resolution that they feel is most appropriate on behalf of the state. So a few things could happen here. It's possible, and frankly very likely, if this goes to a peace bond, that the complainant was consulted. And the Crown gave the complainant a call, and the complainant gave their opinion. Most likely that they're okay with the peace bond. But again, I'm totally guessing here. In other cases, the Crown might just decide it's in the public interest to proceed with the peace bond. To go through with this entire prosecution is not in the public interest. And Crowns have numerous roles, and one of their roles is to look out for Osuna's interests, as opposed to the defense lawyer, whose only role is to look out for Osuna's interests. So all of these things are happening behind the scene, and if that's the ultimate resolution, then I expect that there's been many discussions going on. The complainant's been advised of the resolution, and it was determined that this made the most sense.
Adam, why would the Crown be looking out for Osuna's interests?
The Crown's an agent of the state, and they don't have a client. The complainant is not the Crown's client. The Crown is an agent of the state, has to look out for the public, has to look out for the accused, and also has to look out for the complainant. They have various roles that they play in the system. Compare that to the defense lawyer's role, whose role is to look out for their client within certain ethical obligations to the court, of course, but that's the difference between the role of the Crown and the role of the defense lawyer.
Adam, would Osuna's status as an elite athlete and a popular figure within Toronto be something that the Crown would be taking into consideration when looking out for Osuna's interests?
That's a great question. And I would think not. I would think that they look at the entire picture. And the fact that he's an elite athlete probably should not be a factor, but the fact that he's got a career that could be affected absolutely would be. So elite athlete is one thing, but many other people have careers that criminal convictions or finding of guilt could hurt them for, and the Crown should take that into consideration in determining what they feel is the best resolution.
I find it absolutely fascinating seeing the comments of people on social media, those in favor of Osuna saying, we want him back, and then others that are convinced that he's quote-unquote a wife beater. And I'm thinking the truth probably lies somewhere in between. But is it safe to say that, and we touched upon this the last time you were on, that he was charged with simple assault, that if he was charged for simple assault, any accusations that he beat the crap out of his wife could not be true? Is it possible that he could have beaten the crap out of his wife and still been charged with just simple assault?
It's absolutely possible.
How?
As I explained last time, there's three types of assault. There are four types of assault. There's simple assault, there's assault with a weapon, assault causing bodily harm, and aggravated assault. The fact that he was charged with simple assault means that there were no injuries.
Right,
but
and if he beat the crap out of her, wouldn't there be injuries?
Well, there could be serious assaults that don't result in injury, serious and disgusting assaults. I tend to agree that the fact they didn't lay it leads me to believe it isn't that aggravating, but I don't have that information to say that this wasn't a very serious, but still what the legal world calls a simple assault. We just don't have that information before us. And a lot of the people online, doesn't matter. If you harm a domestic partner, is the fact that there are no injuries make it any less? Sometimes injuries are just happen because of because of sheer luck that there are injuries or that there's no injuries.
Adam, legally,
but we don't know this case. I'm just speaking in hypotheticals here, as we've been doing.
But Adam, legally, then, what's an injury? What's categorized as an injury? Are we talking about the presence of blood, or are we talking about bones broken? What's an injury?
For a simple layperson's explanation, any type of harm to somebody's body. So it could be as little as a bloody nose, or it could be something as serious as actual stab wounds. Now, stab wounds would likely be an aggravated assault, but not necessarily.
So, and again, this is at the discretion of the arresting officer then, right? He's the one who determines what the assault is. Is that up to him?
At first, it is. He or she makes that determination, but a Crown attorney can upgrade or downgrade charges.
Right. Now, let me ask you,
stopping them from doing that.
Let me ask you, and again, this is completely hypothetical, and I don't want anyone to think that I'm assuming that I know anything about this case that I don't know.
None of us do.
Right.
For all your listeners, none of us know anything.
Yeah, and that's the thing. Anybody who claims, and I've heard people say, well, I know someone that says that they know this and that, right? Or somebody, somebody went on the air and said that they, well, no, they don't, right? That's the thing, they don't.
But there might have been witnesses there. There might be people talking to people. Stuff might get around, but I don't know anything.
So hypothetically, you're defending someone who's been charged with this. And the defendant says to you, I was defending myself because she came after me and she started pounding on me, and I literally had to push her away, and she fell to the ground and hurt herself. In a situation like that, do you go through the same process that is happening with the Osuna case, or do you say we countersuit, or we come right back at her because she started it? Like, how does that work, especially when you're talking about violence between a man and a woman?
Well, this is a criminal court, so there's no countersuits in the civil sense. You'd have to ask the police to lay a charge against the other party or lay what's called a private charge. Generally speaking, it's rare to see that happen. The police make their decision at the time, and it's rare for them to add a charge, but not necessarily that's impossible. But your specific question, self-defense is a defense to a charge. So if, in fact, this hypothetical person was defending themselves, then we go through the self-defense provisions of the criminal code and make that argument either informally to a Crown to see if we can get a favorable result, or ultimately you have a trial and you run that defense and hope the judge agrees with you.
So we can safely then say that this probably was not a case of a self-defense, or he would have claimed self-defense, correct?
Again, moving beyond the specifics of this case, it's possible that he is claiming self-defense. It's possible that these are discussions that are leading the Crown to consider a peace bond resolution.
Wow. And this is all stuff that we may never know, though, right?
We're guessing, but we might never know. Wow. There will... If, in fact, there's a peace bond, there'll likely be some facts read into the record. So we'll have the benefit of at least knowing what the allegations were. But at this point, no, we know very little, if not absolutely nothing.
It seems the more...
And also, we talked about last time that there was these rumors that Major League Baseball spoke with the complainant. And we heard Osuna's lawyer say to the media that he doesn't have any knowledge of that happening. So it makes you wonder where they got there.
Yeah. It seems like the more we know about this case, the less we know about this case. It's crazy.
It's crazy, but everything's moving along exactly as it typically does.
Yeah.
Very slow.
Yeah. From a lawyer standpoint,
but it is moving along.
But for us people on the outside, we're like, holy moly, this is just amazing. I don't know if amazing is even the right word. It's wild.
Yeah.
Let's put it that way.
The speed thing, it's a problem. The speed cases do move through the system. It's a problem.
Yeah.
And eventually, hopefully, a government comes in and is able to find a way to fix that. But I don't see that happening anytime soon.
Well, listen, Adam, as always, we appreciate you taking the time to talk to us. And we will continue to bother you with phone calls as things continue to escalate in this case. Thank you so much, my friend.
Maybe if something happens, we'll go to court and we can all check it out together.
That I'm on. Matt and I would love to come see you work.
Yeah.
Well, I'm talking more to watch the Osuna case, but you can come watch me work too.
Yeah, sure. Only if you wear the wig, though.
We want the powdered wig, man.
Well, I'm not that. I'd have to move to Britain to wear the wig. Okay.
All right. I can lend you the wig that I use for my Tom Petty gig. Would you wear that one?
No. Don't do that.
Sounds good.
All right. All right, Mr. Goodman.
Might be my last time appearing in that court.
That's fraudulent or contempt of court or something, isn't it?
Stay well, friend. Thank you.